Hi, my name is Nuruna Junida binti Muhammad Kamal.
Assalamualaikum warahmatullahi wabarakatuh. My name is Zaida binti Muhammad Zawari.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nakibah binti Ahmad.
Assalamualaikum warahmatullahi taala wabarakatuh. My name is Wanafati Izzati binti Wan Syufyan.
Assalamualaikum warahmatullahi wabarakatuh. My name is Tadi Amin bin Muhammad Jamil.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Ashraf Ilman bin Syams Effendi.
Assalamualaikum and hi. My name is Aizana Batisha binti Abdul Sukur.
Assalamualaikum warahmatullahi wabarakatuh. My name is Hansatul Mukminah binti Umar.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aisyah Nurjannah binti Abdul Rahman.
Assalamualaikum. My name is Siti Aminah binti Abdul Hadi.
My name is Muhammad Aiman bin Syaril.
Assalamualaikum. My name is Luqmanul Hakim bin Muhammad Rozi.
Assalamualaikum warahmatullahi wabarakatuh and good afternoon to Miss Wan Zahira binti Wan Zulkifli, Lecturer of Tourism and Hospitality Law for Hajj and Umrah, and our classmates. We are from Group 3 and now we will present to all of you about our 5 law cases that are related to contract and hospitality law.
Before we present the 5 law cases, I would like to first introduce the definition of law itself. Law is a system of rules created and enforced through social or governmental institutions to regulate behavior. Basically, law could serve many purposes. First of all, law establishes standards. It serves as a guidepost for minimally acceptable behavior in our society. And then, it serves for maintaining that order. Furthermore, it's for resolving disputes, using the court system as a formal means to resolve any conflicts, including crime, finance, property, and so on. And then is for protecting one's liberties and rights from violations or unreasonable intrusions from any persons or organizations. Let's see the example of the cases.
Case 1. Ganasalingam Ganagaridam has sued the hotel for serving beef and they intend to strike out of the suit on legal point. This suit was made because the plaintiff had reprimanded hotel, which is the hotel is defendant, on the matter but hotel ignored it and seems like disrespect of Hindu faith, and plaintiff expected the defendant to take the action on this matter. Name of this case is Paya Sarai Restaurant versus Ganasalingam Ganagaridam. The plaintiff is Ganasalingam Ganagaridam, which is he is the customer.
Defendant is the hotel management. Facts of the case. This incident occurred when the hotel management did not segregate the food of its Hindu customer, it is Ganasalingam Ganagaridam, with the other food that containing beef. Issues of the case. The hotel management must be held responsible and respect towards the plaintiff. The decision of the case is the plaintiff, Ganasalingam Ganagaridam, issue a summons to the hotel management because they not respect the Hindu culture. It is most Hindus do not consume beef as the cow and is considered a sacred animal. Then the plaintiff advised the hotel management to segregate the food from the beef meals. With confidence, the hotel management will segregate their food next time. However, the hotel management did not meet the advice from the plaintiff. Again, Ganasalingam go to Paya Sarai restaurant with his friends. The same incident happened. Ganasalingam Ganagaridam so disappointed to the hotel management. Then, Ganasalingam decided to file a suit seeking an apology from the management, damage and other relief deemed fit by the court. Thank you.
The reason behind this case is plaintiff is not satisfied with the action that taken by the defendant because it seems like not respecting Hindu religion, although the defendant said that the beef and other food were placed in a separate container, but it was still negligent and the beef was placed next to other food. My opinion is, I agree with the plaintiff because the hotel and Payasrai restaurant should take an action of all the complaint that given by the customer, because this is involved of food at the restaurant, and it is appropriate for the party to take an action because every customer had become to the restaurant, they present their own religion and belief. It's held as the majority for Hindu are sensitive to beef because they consider the animal sacred, while and this is must be taken into account by the restaurant and the hotel itself so that such things will not happen again. Thank you.
Case number 2. In this case, UTM want to have a grand celebration for its 25th convocation. So, they form a contract with a famous singer named Wan and ask her to perform for 2 hours nightly for 3 nights. In the contract, stated that Wan will receive 25,000 ringgit if she fulfill her contract. But during the celebration, she lost her voice and could only perform for 3 hours only.
The name of this case is University Technology Malaysia UTM versus Wan. The plaintiff is UTM and the defendant is a singer named Wan.
From the contract, we can identify the facts of the case where the case falls under the law contract of employment. The contract are defined as the bind of UTM and Wan on their agreements and come in 2 main forms. Also notice that breach of contract occurs as the issues of the case where defendants are unable to perform for 2 hours nightly for 3 nights that was offered by plaintiff under the employment agreement. The authorities has decided that UTM as the offer cannot force Wan to fulfill the reward on the singing offer. The alternative from the case is that Wan as the defendant has the right to sue UTM for a breach of contract. This alternative only possible if UTM does not provide 25,000 ringgit after Wan has fulfilled the contract's requirements.
Under an electoral contract, only the offer that could be charged with a breach of contract, meaning that UTM can charge Wan, the famous singer, for a breach of contract. A clear indication that only Wan can sue UTM. But under this, that one of the famous singer has also not fully performed as required by UTM. An indication that there is no legal obligation from UTM to Wan under their unilateral agreement. So, an unilateral contract means any legal agreement where only one party makes a promise that is legally enforceable. For the conclusion, I agree with the decision made because this case of the contract between UTM and Wan is not valid until the terms in the contract are complete. This is because contract that made by UTM is an unilateral contract, which means only one party issues terms.
Now, back to third case. Next case is a landmark judgment today could have far-reaching repercussions beyond hotel. The federal court ruled today by that hoteliers cannot use 10% service charge paid by customers to meet the minimum wage requirement. Instead, must pay their employees the charges collected in addition to their salaries. Okay, the next part is from that case. From that case have a 3 part, which is the name of the case, plaintiff and defendant. Okay, let's go to the name of the case first. Name of the case is Crystal Crown Hotel and Resort Sedia Mahat versus the National Union of Hotel, Bar and Restaurant Workers. The second one is plaintiff, which is a staff Crystal Crown Hotel. And the last part is defendant is hotel management.
The fact of case is service charge collect from the third party does not belong to the hotel. Issue of the case, hotelier can use the 10% service charge meet the minimum wage requirement. Instead must pay their employees in addition to their salaries. Decision: hoteliers are entitled to utilize all of the employee service charge Service charge can be incorporated into a clean wage or utilized. Rationale and reason. Naliani was giving a judgment in a civil between Crystal Crown Hotel and Resorts Berhad and the National Union of Hotel, Bar and Restaurant Workers. Conclusion: there are no compulsory tipping. 10% service charge is imposed on all bills to customers for service.
Case 4. Awal and Shah claimed DHUM to fulfill its responsibility accordance with the basic term of agreement and failed to return 3,215 bottles of perfume which were said to be damaged, failing to provide record of sale transaction and refusing to pay for the losses. Name of the case: allegation of breach contract agreement, the exclusive distribution of perfume of the brand Blue and Maroon. Plaintiff: Awal Ashari and Shah Al Yahya. Defendant: DHUM STN BHD.
Okay, I will continue about the case. Case fact. So, plaintiff has alleged that DHUM did not fulfill its obligation in accordance with the basic term of the agreement and failed to return the 3,215 bottles of perfume allegedly damaged, as well as failed to provide record of sale, transaction and refunds to pay for loss. The problem of the case is DHUM has to take responsibility for the loss. After trial court decision, plaintiff Awal and Shah were awarded damage of Rm 345,305 after winning their claim against DHUM on change of breach of contract. The session of court also allowed a counterclaim filed by DHUM and ordered Awal and Shah to pay 55,000 after finding the couple breached the agreement by selling the perfume itself in Brunei. The reason for this case is because the defendant failed to discharge his obligation in accordance with the term of the agreement policy and failed to return the 3,215 bottles of perfume allegedly damaged, as well as failed to provide record of sale transaction and refers to pay loser. My opinion, I agree that the plaintiff was entitled to compensation of 3,4,535 ringgit from the defendant failed to perform his obligation in accordance with the basic term of the agreement.
Today, I want to talk about the actress Ellie Surati was ordered to pay 7,200 ringgit in damage to a film production company after she was found to have breached the contract agreement in the KL film Cinta Mandi Talk. In the case, the plaintiff is Wat Merpati Entertainment Sdn Bhd and the defendant is Ellie Suryati. The fact of the case is company Wat Merpati Entertainment Sdn Bhd had to bear to loss of 20,000 because actress Ellie Suryati had breached the contract of filming absence agreement according to the promises date. And the issue of the case is Ellie Suryati should be responsible for the losses incurred by the film production company.
The decision of this case, court allowed to company suit and order defendant to pay special demands of 7,200 because breached the contract. The base of the reason, defendant failed to perform his responsibility in accordance with the term of the agreement policy. is called the will entertainment sedang berhad to surface laws. Conclusion, this case, action take by plaintiff against defendant is acceptable. Clearly, the actor guilty. Company need to be more sensitive what is happening. Need to care about the right and employees so that the company reputation is guaranteed even more.
There are two conclusions. First conclusion is about hospitality case. Tourism and hospitality industry link closely with the law and regulation. It can help to ensure both tourists and industry operators come within a fair and equitable environment. It is also very important for industry operators to have the knowledge of it, so it can make sure that they can prevent legal suit being initiated for fine being imposed of them. Therefore, to avoid legal issue in the future, parties must come to an agreement by setting a value to specific good service or job performance. Besides consideration legally with a contract, protecting both parties from potential lawsuit or misunderstanding. In addition, consideration often include a section that determines loss responsibility. Lastly, but not least, having a contract that clearly states this information helps a court to determine where the value accurate, who is at fault, and what penalty to award. Second conclusion is about contract case. To avoid legal problem in the future, the party must enter into the agreement by assigning value to certain goods, service, or work performance. Therefore, the consideration of entering into the contract legally protect both parties from possible lawsuit or misunderstandings. In addition, consideration often include the part the dominant responsibility. Having a contract that clearly states in this information help the court to determine where the values according who is at fault and what punishment should be given.